My name is Tiffany Gauthier, and I work in family law at the law firm of Penner and Purves. We've handled so many divorces, separation, and child custody matters that we understand that every single person's case, family situation, or divorce are unique, and we are dedicated to tailoring our legal representation to clients' specific circumstances so as to help our clients accomplish their goals, to provide legal protection when needed, and to provide structure for endangered child-parent relationships when there are child custody disputes. But while we assist client after client in filing divorce petitions and divorce responses, and we pride ourselves in the quality of the work that we do for each client, today I have an offer for those of you who do not want a divorce. In the state of California, we have what is now called no-fault divorce. That means that you can just file in the court to obtain a divorce, check the box on the form that says irreconcilable differences, and the court will grant you a divorce judgment. How is that a no-fault divorce? Irreconcilable differences, and the court will grant you a divorce judgment. How is that a no-fault divorce? Irreconcilable differences can mean almost anything. In fact, I have a secret for any of you who are not married yet. In every single marriage that exists, the spouses have differences that are irreconcilable. Ask any married couple that you know if they have irreconcilable differences, and they will laugh. This applies to 1-year marriages, to 10-year marriages, and to 20-year plus marriages. Therefore, under California law, there is really only one single requirement for filing a petition for divorce, and that requirement is that you are married. This means that the court is no longer interested in evidence for how one spouse harmed, cheated on, or otherwise broke promises during the marriage. The divorce case will not be about those things. Instead, every California no-fault divorce case is simply about division of property, establishment of financial support if appropriate, and setting of child custody and visitation orders if there are children. And this has led to something that is unfortunate, because it is so easy to file for a divorce, and because the court will always grant a divorce, even if only one spouse wants it. Too many divorce lawyers do not handle clients who come into their law office stating that they want to save the marriage. The standard response that these people are given is that the divorce is inevitable because the court will always grant it. So let's just plan on a divorce. At our law firm, we do not do things that way. Instead of looking at every single petition as always leading inevitably to a divorce, we have a reconciliation track that we can start with any of our 3 divorce family law case management plans. Whenever a client hires us for a divorce case, we agree early in our representation if our approach for the case will be 1, the amicable plan for spouses who have no disagreements for a divorce and who therefore simply need guidance in completing the court process and obtaining a non-contested marital settlement agreement. Plan 2, the settlement plan, for spouses who have some disagreement but do agree to save the costs of a divorce trial by negotiating or mediating their disagreements so as to settle their case ultimately out of court, with the end result of a non-contested divorce judgment. Or option 3, the trial plan, for spouses who have both disagreement and no agreement to settle their case out of court, and who therefore need to plan for the court to resolve things after taking their contested divorce all the way through trial. But no matter what family law case management plan you end up with, you can also elect in engaging us to pursue a marriage reconciliation track first as part of your engaging us. For any client who engages us, starting with the reconciliation track, we will plan to do the following. First, we will explore whether an agreement could be reached to put the divorce process on a temporary hold in order to pursue marital counseling and or other time investment and problem solving on the issues that led to the other spouse filing the divorce petition. Second, we will explore whether an agreement could be reached to obtain a legal separation. First, which it is true can always be amended into a divorce later, which in some ways offers family, and financial protections, depending on the circumstances that a divorce does not. Third, we will both send a marital reconciliation proposal letter, even offering to agree negotiation and enter into a marital reconciliation agreement as a first alternative to a marital settlement agreement, usually with terms that, if not complied with or successful, can still lead to a legal separation or a divorce. And we would reach out to the other spouse or opposing divorce attorney and clearly communicate that our client is interested in saving the marriage and proposes to discuss exploring that. Then, as a last resort, if the other spouse refuses reconciliation, our method of representing clients who do not want a divorce in divorce cases is to approach everything in a case with the design and intent that if with the passing of time a reconciliation could still be possible, we are not going to litigate the case or seek a judgment in any way that would diminish that possibility. So what is our offer? Our offer is simply that, as another part of the reconciliation track plan, we will include a 15% discount on our attorney's fees as a part of your retainer agreement. Every time we send you an invoice, it will include that 15% discount, and this discount will be our small way of commending and encouraging any spouse who maintains a commitment to saving his or her marriage in the middle of a divorce. If this is something you are interested in, just let us know when you have your first divorce consultation with us. It will be our honor to serve you.